Hello, I'm Luke Zadkovich. I'm a partner at the international law firm Floyd Zadkovich. This is a talk in our ongoing series on how to deal with an economic crisis as an international business. And in particular, today's talk looks at the maritime sector, one of the sectors that we focus on as a firm. I'm primarily looking at vessel arrests today from the perspective of the arresting party. As a firm, we also act regularly for ship owners too, and our experience in arresting ships certainly comes in useful when we're on the other side and we're defending arrest applications as well. But in this current climate, I thought I'd touch today on how to bring an arrest application and some of the factors really in considering when doing so.
Floyd Zadkovich, International Commercial Lawyers.
So in this series, we are looking at a number of tools and strategies that international businesses can use to help mitigate risk and protect themselves in a financial crisis. Today's talk is on vessel arrests. So I'm talking about ship arrests here, and they can happen all over the world. This is our bread and butter, so to speak. We deal with them all the time. I must have been involved in vessel arrests in 60 different countries, probably more in all my time. And my partners is something similar. So it's what we do. And in difficult financial times, if you're involved in shipping, whether that's on the cargo side and looking at ship arrests, or indeed whether you're a ship owner and you're concerned about having your vessels arrested for outstanding debts or to enforce liens, then this is a really critical area of this part of the law. And so when you're thinking about ship arrests, you're on the arresting side of things, you're thinking about claims that are against the ship. And we're going to focus just briefly. I'm going to try and keep this as short as I can on ship arrests using Rule C in the US. And this is where you have a maritime lien, a in rem claim against a vessel. So it could be a cargo claim against a ship where it's damaged the cargo. It could be that a ship has had provisions, some type of necessaries provided to the ship, and they have not paid, and so the supplier has a claim against the ship. Could well be a claim against the head owner for some type of contractual claim, which runs to the ship and creates a maritime lien. So these types of liens are enforceable using a federal rule of civil procedure in the US called Rule C. Rule C arrests are quite common. They're relatively easy to obtain. You do not need to post large counter security. You cannot obtain them against sister ships per se. It's not like South Africa where you have an actual statutory provision that allows for sister ship arrests. In the US, you can go after a sister ship if there is a basis for arguing that that associated vessel is an alter ego of the party that you have a claim against. But that's actually in a Rule B context, more so than a Rule C context. So when we're talking about Rule C, we're thinking about going after the ship that was actually involved in the contract or in the trade or in the issue that has arisen. And as I say, that's just on the US side. We advise on both US law, English law, and also Australian law as well. And we've handled multiple arrests in those jurisdictions ourselves all over the US. We are lead counsel in states nationwide in the US, and handle arrests anywhere, frankly. Internationally, we also project manage arrests anywhere in the world and have really deep experience doing so. And this is because often the underlying claim for which you are arresting a ship to get security for that claim is often an English claim, which is my background, or a US claim, which I am also a New York attorney, but my partners in New York, Chicago, and Houston, those offices there, they are regularly handling the US arrests. So in our firm, we have that capability to advise on both English and US and also Australian law. And so when we're looking to arrest internationally, we've been following a ship, it turns up in some jurisdiction outside of those core countries that we operate in, then we pull in local counsel, and we have a really extensive network of local counsel in almost all countries, really. I've been doing this for over a decade. I think it's more like 12, 13 years now. I also had time in one of the international group P&I clubs, and through those roles, I've developed a very extensive network of foreign local counsel who are very competent in handling arrests. And I think it's often surprising to a lot of clients that we can arrest ships in most countries, and even in countries where there may be a perception of less sophistication, the arrest rules and procedures are often, quite well laid out. And the maritime lawyer that we would tend to go to in those countries is often a very senior person in the legal jurisdiction. They have a lot of sway with the local courts and clout, and that's what you're looking for. And so, yes, there are more risks arresting ships in, let's say, less certain jurisdictions, but it's still possible. And if you have a major claim where you want to try and get security from a ship owner, tying their ship up in a jurisdiction that's less well known can be actually riskier for the ship owner as well. So it can actually work as quite increased leverage, and the owner can, for example, be looking at having its ship arrested in a jurisdiction for quite a long period of time. So we work very closely with local counsel in those jurisdictions. There are a number of issues to consider, such as counter security. What are the formal requirements for bringing the arrest? Some jurisdictions require notarized power of attorneys. They require original documents. They require, like some of the Arabic jurisdictions like Lebanon, they require all the documents to be translated into Arabic to be able to bring the arrest jurisdiction. If you're having to move quickly, which you often have to do in arrests, then having the translations of core documents takes time. And these are all factors. There's a number of factors to consider in arrests. It's important to have legal counsel who are well-versed in this. And as I say, the importance of having English and US lawyers project managing or working cohesively with local counsel is so that whatever's done in the arrest doesn't prejudice the underlying claim. You don't want some admission or some way that the claim is crafted in the foreign jurisdiction to impact on the underlying claim. Like, another point that just comes to mind as I'm talking is, in some arrest jurisdictions, you are actually commencing substantive proceedings. So how does that interact with the underlying jurisdiction? You don't want, often you want your underlying claim decided in England, and because it's more certain for dealing with substantive rights. You don't want your underlying claim dealt with in a jurisdiction that's going to be looking at the English law as a foreign law in that jurisdiction that are not well versed and used to dealing with English law. So when you're initiating the arrest application, you need to consider what is the nature of this arrest? Is it substantive as well as just interlocutory and for security? And there are a number of issues and factors to unpack and to work through with local counsel. There are other factors around the type of security that can be posted to release the arrest. In a number of jurisdictions, they will insist upon a local bank guarantee. How do you obtain a local bank guarantee? Do you know how to do that? Do your lawyers know how to do that? These are things that, as I say, they're bread and butter for us. We've been dealing with them for years and years, but there are nuances involved in vessel arrests. It's a very common tool that's used for international shipping lawyers, but one that needs to be considered quite carefully and often in very urgent and exigent circumstances. I've focused primarily on if you're the arresting party and you're looking at vessel arrest from the arresting position. We also act for many ship owners and on instructions from P&I clubs as well in defending ship arrests. We've had a very major misdelivery claim where we're on for the ship owner that involved Dakar, Casablanca, Mauritania, Switzerland, the US, and England, all on one dispute. Sister ships arrested, misdelivery happened in one jurisdiction, should have been in the other. We had freezing injunctions brought in that case because of the risk of dissipation. We ultimately got security in the US, and it involved a lot of coordination. I was sitting in the London seat on that one. My partner was in New York. I was project managing it. Ed, he ended up obtaining the security in the US, and I had to fly to multiple African jurisdictions to handle the arrest jurisdictions, and we were defending that for ship owners. We also gathered evidence. That's another important factor in a ship arrest, because what you can do is you can use the arrest proceeding as a way to also obtain early discovery and to obtain evidence. So again, going back to looking at it from the arresting party's perspective, you might want to take depositions of the master, of the crew, obtain the ship's documents, and tack that on as additional relief as a part of your arrest. So there's a lot in it. There's a lot to think about. I've tried to cover a lot of aspects of this in this discussion, and I probably put a lot on your plate. This for me was a condensed talk on the topic. I could talk for it easily for a couple of hours. If you have questions on vessel arrests anywhere in the world, get in touch with us. I hope you found this interesting. It's as I say, one of a series of talks we're going to do on how to deal with the financial crisis as an international business. If you found this talk of interest and valuable, please do share it on to your network, to your contacts, to your colleagues in your businesses. It would be very much appreciated. That's how we get our name out there, how we help more businesses, how we help our clients and our network. Have a good day. Stay safe and healthy, and all the best. Thank you.